I'm not a sovereign citizen.
If those things work,
Don't put
everybody would
don't put that on me. I'm not a sovereign citizen.
Turner, you've made statements that sovereign citizens, and so
I have my trust set up, and
Okay.
I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me.
But you are being rude. You're deliberately cussing and you're not listening. Well,
you know,
everybody here in
you would get frustrated with someone else out here, and you can do what the fuck you want.
But I treat people with respect, and I expect you to do the same.
Well, how do
Everything is nonsense. None of what you're saying makes sense. None of what, Ms. Turner.
It's federal law.
Ms. Turner, we're not in federal court.
01, the people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tanea Tubbs.
Ms. Tubbs, can you unmute and state your name for the record, please? Ms. Tubbs, if you can state your name for the record, please.
Grand Rising, I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tanea Nicole Tubbs, the beneficiary.
Okay, and Ms. Patilla is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that, but if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you. Okay. You're gonna represent yourself, but if you have any questions, you can ask her. All right.
I hear you, sir.
All right. Do we have a jury trial date on this? We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial
and I have ruled that she can represent herself, haven't I?
Yes.
Okay. All right.
And that's why the other counsel was relieved and
okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and your and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public would not hear.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patella?
No, sir.
All right, Ms. Patel, I don't think I can order her to do that, so, Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. What would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me. Not being smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Ms. Tubbs. So she apparently, will you be willing to have Ms. Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you. I'm not willing to.
All right.
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
you're
you tell
forcing me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to me. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell me.
She can have her in the courtroom, but not on my behalf. It could be on her behalf since she's fearing what I have to say alone. I'm not understanding why.
Put the three of you in a breakout room to discuss things.
Okay, thank you.
Do you agree to that, Ms. Tubb?
I agree to speak with her with the third party on her side.
All right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay, thank you.
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
Is there anything else we need to take care of before we send you into the room with Ms. Tubbs? Is there any other matters that are ready? Madam Clerk?
Yes, we could take care of Mr. Kehoe.
Well, you know what? It's too complicated. Let's let them do this. Can you come into the breakout
Yeah, I'm gonna go into the conference room and log into Zoom.
Okay, all right.
Oh, I pray we wake up.
Let's see. Let's go back on the record with regard to Ms. Tubbs' case. All right, let's call Ms. Tubbs' case, please.
Calling case 2400390201. The people of the state of Michigan versus Tania Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozek on behalf of the people, P78815.
And good morning, Judge Dion Patillo, PA2378, stand-in counsel for Ms. Tania Tubbs.
All right, Ms. Tubbs, if you can unmute and state your name for the record, please. All right, you can speak now. I think it's unmuted, ma'am. Yep, I can hear you. Yep.
For the record, I am Tania Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. Do you agree to waive that right for today and hold this hearing by Zoom?
Correct.
Okay. All right, where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs and I did look up I know that the defendant is in Calhoun County Jail right now and that she has a sentencing date of March 24th, 2025. When is our trial date? The 17th?
March 17th.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here, and maybe we should have a pretrial before the trial once Miss Tubbs is here, where we're all in person. And Miss Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th, if that works for the court, prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay, all right.
Excuse me, Your Honor.
Yes, go right ahead, man, Ms. Tubbs.
I am looking forward to being out of here before then. And it is my duty to come there on my own as a freeborn sovereign to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district, and I'm not going to be able to get this paperwork if I don't be able to walk and go get it, go home and print it out myself, because I have none but 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to help me any longer.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're gonna be in the jail here, Wayne County Jail.
What I'm telling you is that I'm gonna be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity or MI entity. I am a living being.
All right, you have a nice day, ma'am.
Thank you, Judge.
Okay, thank you.
Okay, I'll see you all on the 6th. Have a good day.
All right, you
Thank you.
too.
Thank you.
Do we have a whole week planned for this one? We set aside a week?
Is it a we?
I don't know. But I'm thinking it might actually take a week, where we'll see.
All right.
So March 6th is at 11:30.
All right, you were in front of Judge Hill back on June 10th, and we reset the case for today's dates to allow you the opportunity to see discovery, the police reports from the prosecutor's office on that case. I don't know whether you've received that yet. Have you received the police reports from them, the discovery?
I got the police reports. They're all false.
Okay, so
I couldn't see the video from the police camera.
okay.
I don't know why. I mean,
Sometimes I think I've seen that they send a link.
To this day, I can't get that.
You weren't able to.
Right.
So it might be worthwhile having a follow-up conversation with them, because what you're saying to me is you don't agree with the facts that are in the police report, number one, and you couldn't review the video that you were hoping to be able to see, right?
Yeah.
So
Yeah, but I also just want to, try and get this done.
and that's.
I got things to do, this is taking a lot of my time right now.
I understand, and that's part of the process. Obviously, when you get charged with a criminal offense, it can take some effort to get it resolved. All I can do at this stage is give you the options that you have. You haven't entered a plea to any charge. If you decide to plead guilty to the charge, then we would go forward with a guilty plea. But if you'd like to have a conversation with the prosecutor and have a follow-up conversation with them, you could do that this morning.
You know, I honestly don't know what to do anymore because this is just gonna take up more time waiting for a prosecutor. I'm not guilty. I'm innocent and innocent. You know, I don't know how else to say it to you guys. You know, but I don't know what else to tell you, honestly, dude. I've been dealing with you guys for a lot, you know, for unreasonable reasons, for false accusations. I just want to be done, man. Get the fuck out of here. Be done with you guys in my life. Continue with my life and my family, my kids. You guys have just gotten accusations, false accusations from people that don't even fucking know me. You guys take the charges, hammer me with them, and try and get money and 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 money off me every fucking time. I'm done with it. I'm fucking sick and tired of you guys. The police charged me with shit that I should not even got. I got my ass fucking handed to. I'm not gonna lie, dude. I got my fucking company, my kids. I stood like this and let these people beat the shit out of me. I do not deserve anything of what you guys are giving me. I do not deserve any of these fucking charges.
Sure.
I got my fucking ass beat by 5 guys and that's brawling? How is that brawling? They jumped me. That's all there is to it. That's the truth right there. I don't know what the fuck you guys gotta keep sorry for my language, what you guys gotta keep investigating for 3-4 fucking months.
So let me try to, and I want you to take a couple deep breaths if you don't.
Like, this is taking my time, man.
I understand.
Last time I came here, I lost work. I couldn't pay my rent because of that shit.
So can you pause for a moment so I can respond to what you said?
Well, at least you gave me time to talk, so thank you. You guys never give us fucking time to talk.
I want you to be able to be heard, and
Well, I want this to be done. I didn't do nothing.
I understand what you're saying. I just want you to understand the judicial process.
I know the traditional process,
Well,
man, and it's all bullshit.
It sounds like you don't understand the roles. Let me explain.
I do understand.
I don't have any
I've been in your
authority.
system since I was 13 years fucking old, dude.
All right.
You guys do not let me go.
Can I speak? I just want.
Go
We
ahead.
can both speak, but you got to let me talk too.
Okay.
Okay. I don't have any authority over the executive branch, which is the prosecutors and the police department. They may have decided that they think that there's a charge that they can prove against you. My job is to make sure that you have your fair rights addressed here in court. The only way we can do that in a fair way is for me to tell you about the charge that's been presented to you.
She does, right?
What's that?
She does, right?
She's the prosecutor.
Yeah,
So
she should have that, what you're saying, because I spoke to her last time.
She does have the ability to make decisions on how the prosecutor's office wants to proceed with the case.
When
That's
she's
her.
here, I don't want to take time to talk to her on the outside.
You
Do
do.
this now?
You want to talk? Well, there are other people in front of you, so she may not be able to meet with you this moment, but yes, you
No, but
can have a
you said she has
conversation.
an offer from me. You said she has a case that she could file against me.
She doesn't have there's not an offer in the file.
So what's gonna happen? Are we just gonna reschedule this hearing again and go through the same
We
stuff?
don't need to reschedule it yet. You're here today. If you'd like to have a conversation with Ms. Keller, when it's your turn to speak with her, you'll have that opportunity. So there's other people who are waiting to see a prosecutor. You'll get a chance when it's your turn. Understand that she represents the government's interest. She represents the police department's view of the case. She's provided you the discovery. You all can have a conversation about it. If you decide that you do not want to enter any type of plea to the charge, which is perfectly within your rights.
I could pay you guys money. What do you guys want? How much do you guys want? I'll go pay that shit right now.
That's not what I'm interested in. I'm
I
interested.
am, man, because I don't want to see you again. I want to see her again.
The charge is brawling. It's not that simple where someone just pays a fine and it's over. It may not be that simple.
There was a $50 fine on it.
No, that's the bond amount. That means if you had failed to appear, then you would have to post a bond of $50. That's different than a
Alright,
fine.
man, I'll talk to her, man, because I'm just done with you guys, dude.
I need you to be patient with me because that's
I'm
one of the
done being
charges.
patient with you guys. You guys are never patient with me. The moment I do something dumb, you guys fucking put my ass locked up, get my ass charges. Never fucking patient. You never hear my side, so let's do this shit quick, man, and get it done with.
There
I'm
won't-
not trying to be rude, but you guys have taken so much fucking time of my life.
But you are being rude. You're deliberately cussing and
Because
you're
I'm
not
done with
listening.
you, man.
Well,
You know?
everybody
Just
here in
like
the,
you would get frustrated with someone else out here and
Yeah,
you can do what the fuck you want.
but I treat people with respect and I expect you to do the same.
Well, I'm tired of you guys, man, because I didn't do nothing. And you guys are treating these other people that did harm me like fucking victims, like they're precious.
I've asked you a couple times to watch your language. And I'm being pretty patient about it, but I want you to have a seat, because if you said you wanted to speak with Ms. Keller, so if you can have a seat. When it's your turn to speak with her, you'll have the opportunity.
He wants the case over today, so frustration is replacing strategy. The judge is still offering a path to negotiate, but anger can make a defendant reject leverage, damage credibility, and hand control back to the system he says is against him.
And Ms. Keller, there are two charges that are pending. There's the brawling charge, and there's a second case that involves making unreasonable noise and use of fighting words. So the second case I haven't addressed yet with Mr. Bello.
Thank you, Your Honor. Is the second case more recent than the?
Yes, no, it's an older case, actually. So I can go through the history with you on that, but you'll just want to look at it and see what the status is for that older case.
And I just want to clarify, I know he was represented by Ms. Toline on an earlier case. Is that?
That case concluded.
Okay.
Yeah, we have not, he's not asked for public defender, but I want to make it clear, did Mr. Bello, Mr. Bello, if you decide that you'd like the public defender to represent you, you can. I think he's saying he does not want the public defender to represent him. So you can have the conversation with Ms. Keller without counsel present. Yes, you do. So you can get him called. All right, Ms. Keller, you're standing. Hang on a second, Mr. Lau. Ms. Keller's standing, so she might have something to talk to us about.
Yeah, can we, Mr. Bello's trying to get to Cheyenne, so if we could call him up.
Yes, we can recall Mr. Bello.
Thank you, Your Honor. I've had a conversation with Mr. Bello this morning. There is a deferred prosecution offer in the file. The only affirmative condition is that he complete mediation with Mr. Martinez. This is the alleged other party for this charge. I've told Mr. Bello I want him to make a good faith effort to complete the mediation. If the mediation does not work out, the city is willing to dismiss this case, but I want to see a good faith effort that he tried to complete it. I don't know if the other party will complete it. I know it's a two-way street, but.
And is that Michael Martinez that would be expected to participate?
That would be Alejandro.
Alejandro, so different Martinez than I'm thinking of. Okay.
Yes, it's in the deferred prosecution.
Okay, so a deferred, and that's to the brawling charge in case number 2025-2616. So a deferred prosecution, Mr. Bello, means that you don't have to plead guilty to anything. You're not pleading guilty to a charge. Have you taken a position with respect to the fees associated with that, Ms. Keller?
Your Honor, given this situation, Mr. Bello has had to move. He's traveling a significant distance to see his kids. The city's going to ask for a waiver of fines and fees.
Okay. So it's case number 2025-2616. There is a deferred prosecution offer in the file. The condition of the deferred prosecution is that you not be charged anywhere in the next 3 months with a charge of a criminal offense that results in a guilty finding. And then the other condition is that you make a good faith effort to complete mediation through the Community Mediation and Resolution Center for the City of Boulder. So you'll be given their contact information. You're going to still have a quick meeting with Fernanda, who's our probation officer. She's going to give you the information for the community mediation folks. I don't get to decide what good faith effort means because I think you and Ms. Keller have had that conversation. But you're going to need to at least contact those folks and be willing to participate in a mediation. That's what you'd be expected to do. Based on the request from Ms. Keller, I'm going to waive the deferred prosecution fees associated with the case. And it might be worthwhile for some follow-up from the prosecutor's office with the mediators so that they're familiar with what your expectation is. I wouldn't want to get a letter back saying the person's failed to comply and then we have to address it.
I can reach out to them today and just give them a heads up.
That sounds great.
Yeah. Yeah, my sincere hope is that this will lead to a better living situation for everybody.
Okay, thank you for that, Ms. Keller. And then I want to just pull up the other case because there were two cases that were filed here. One is the older case. We didn't address that on the record, but I want to make sure that we have addressed it. This is case number 2024-2805. So back in June on that case, if you'll recall, you were in court. You, at that time, Mr. Bello, you pled guilty to a charge of making unreasonable noise. And I imposed fines and costs, suspended most of those fines and costs on the condition that there be no similar violations. I'm sorry, not making unreasonable noise and use of fighting words. And so there was a show cause order issued in that case. So I want to just check in with Ms. Keller on the show cause situation. It was scheduled for a show cause advisement for today's date. Obviously, the allegation was based on the new charge. With the deferred prosecution, it's not technically resulting in conviction. So do you have a position with respect to how we should proceed on the old case?
Your Honor, since the new charge doesn't technically result in a conviction, I think the city should withdraw the show cause.
Okay, so there won't be any action taken on the other case. Thank you for that, Ms. Keller. I'll make a notation for our probation officer. CA withdraws motion for show cause. That case will remain open. Let's see, it was a suspended sentence for 12 months, so it remains open. Well, at this point it doesn't, because it was June 11th when you entered into that case last summer, and it was a 12-month suspended sentence. So my understanding would be that there would be no longer be any conditions at this juncture on that case because the 12-month suspended sentence has now been completed.
That makes sense to me.
Okay. So that case can close. So just one case will be open. We'll have you meet with Fernanda. She'll go over all of this with you. She's going to give you the contact information. I'm going to waive the deferred prosecution fee, and you'll have to contact community mediation to get to go through the mediation process through the city. All right. Any questions for me?
Sir, apologize.
Thank you.
Apologize.
Okay. I know it's emotional. Down to see Fernanda. Be polite with her, please. She doesn't.
I will.
Be hassled.
You guys actually worked for me this time.
Yep.
Thank you.
Salah Holdings, Define Gresham, and Larry W. Johnson. All right, is there Ms. Turner, Latata Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right,
Okay.
so Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named. Okay. And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer
Yeah.
for Mr. Widener.
Intended to name me too. So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible allegedly for what you are contending happened, but then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney of fact on behalf of the principal, who is the registered agent. I already submitted the Form 56 upon you over the matter to administration on behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee. And Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you transferring this case to Superior Court. But just as an aside, Ms. Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else involved.
Ms. Turner,
in this executive branch, I do have a right to sue them and anyone else involved.
It's nonsense. None of what you're saying makes sense. None of what, Ms. Turner,
it's federal law.
Ms. Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
no, it's not a sovereign. It's not. I'm not a sovereign citizen.
If those things work, don't put everybody with you.
Don't put that on me. I'm not a sovereign citizen.
Turner, you've made statements that sovereigns use, and so
I have my trust set up, and I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
Okay, if
Not
you
a
said,
sovereign citizen.
all right, Ms.
That's
Turner.
against the law.
Okay,
I'm not a sovereign citizen. So I have my trust set up
okay,
in a way that it's working for me and I have it set up.
okay,
And that's what I'm working on, my trust.
okay. All right, so we'll get that order out. Thank you. You're free to go at this time.
Thank you, Your Honor.
This hearing shows how fast a case can change when emotion stops driving the wheel. Minutes earlier, the defendant was treating the courtroom like a fight to win. That usually helps the prosecution more than the defense. Outbursts can distract from weak evidence, bury legitimate complaints, and make the court focus on behavior instead of facts. But once the conversation became practical, the outcome changed. Instead of pushing toward trial, the case moved into deferred prosecution. That matters. No guilty plea, fees waived, and a route to dismissal if conditions are met. That is a major difference created not by a dramatic legal argument, but by one strategic shift: cooperation. The judge also protected the record. He explained roles clearly, separated bond from fines, and made sure the older case was addressed correctly. Courts often respond better when someone moves from confrontation to problem solving. There's a lesson here bigger than one defendant. Many people believe forceful emotion proves innocence. In court, it usually does the opposite. The system rewards patience, documentation, and timing. It punishes chaos, even when the person underneath it feels wronged. For sovereign citizen viewers and anti-system thinkers, this is where many cases collapse. Energy goes into resisting process instead of using process. The courtroom does not run on personal certainty, it runs on procedure. Today, a man walked in furious and walked out with a softer landing than he expected. Sometimes the smallest decision is choosing to listen before the consequences harden.